Good morning, Taran. Good morning, Soumya. Good morning, Prableen. So, I hope you all are doing fine and you are in, discourse of learning and preparing for your competitions. Good morning, Lipsa. So, a very warm greetings of the day to all of you, Taran, Soumya, Prableen, Lipsa, Bad Jazbad, Utum, and everyone whosoever has joined. Mehul, very warm greetings of the day to you all. And now we shall be beginning with the topic. The topic is for the day is the closing the gaps in criminal justice. Now, closing the gaps in criminal justice is because our criminal justice system. Are you able to hear me? Am I audible and visible to you properly? Are you able to read the document clearly? Okay. So I was talking about closing the gaps in criminal justice. I was talking about the criminal justice system in India. The criminal justice system in India suffers from many shortcomings and handicaps, and there are so many loopholes in our criminal justice system. There are so many gaps in the criminal justice system. And those gaps, they lead to delay in, at every stage in the process of investigation, in the process of bringing the culprit to the books. It takes a lot of time. It is a very time consuming process. It becomes quite cumbersome. It becomes quite irritating sometimes. You know, in a country like ours, it is very difficult for a common man to get even an FIR registered against the perpetrator, whosoever has committed a crime against him. Can you imagine that you being a lawyer cannot perhaps realize the importance of the importance of the pain that a common man every day has to go through. I have been I have been in cities sometimes. Some time back, I was in in the capital city of Uttar Pradesh, and I was told that you should be very careful while parking your vehicles, parking your bikes somewhere at a point, because you should keep them locked every time, because it has become very usual that bikes are stolen from the parking area, and at this point of time you cannot even get an FIR registered in the police station. And even if somehow using the source or pressurizing the police in some way or the other, you can, if even if you get it registered, the police is not going to do something. So perhaps you might agree with me or you might disagree with me. I don't know whether I may be wrong, and perhaps this is just what I observed, and you might have had a very good experience with the police and with the criminal justice system of the country. But so far as my experience is concerned, it's very bitter. It's perhaps the worst ever experience I have ever had with anything. So, you cannot get an FIR registered simply. So, right from the stage of informing the police about the happening of a crime, up to the trial level and up to the appeal level, it's not easy. The whole system is rotten. A system can survive if the whole system happens to be very good with some rotten eggs. Some rotten eggs or some rotten apples can be avoided, can be ignored. But when the whole system happens to be the rotten system, it becomes very difficult. Lipsa Chaudhary says same happens with mobile phones. Exactly. Once your mobile is gone, it will never ever come back. The police will put it on surveillance. the police is going to investigate. The police is not going to investigate anything. You might think that the police is going to investigate. Police is not going to investigate. Okay, police is not going to investigate about your mobile phones. I have not seen any mobile phone coming back to the person concerned. Never ever happened. This usually happens, and in India it's very difficult for to get back your stolen property. It's very difficult to get back your stolen property. Very, very difficult. And it's not difficult for the police. Nothing is difficult, in fact, for the police. The police can apprehend the thief, the police can apprehend the perpetrator any place at any time it wants, provided that the police is willing to do that. There is a lot of reluctance on the part of the police to do anything. Some time back, my sister had to face an online fraud. I got the complaint registered with the cyber police. The cyber police was successful in getting returned part payment. Okay, one installment of the money was returned back, but the other one was not. The question was that if one part of the money can be returned back and the cyber police was successful in getting it back, why not the other part? And what is the police doing? It's very easy for the police authorities to apprehend the perpetrators in cyber crimes. You can address the IP, you can trace the IP address, you can trace the mobile phones, you can trace their locations through IMEI number. Everything is possible if police is willing to do it. Okay, if the police is willing to do it. The police today hardly cares. And besides, it's not just police. It's not just police. Even at the trial level also, there are so many delays, there are so many hurdles in the trial process that this is in itself a very big punishment for the litigants. जेल से पहले जो सजा होती है, जो दोनों लिटिगेंट्स को फेस करनी पड़ती है, वो कोर्ट में आने की होती है, कोर्ट प्रोसीजर्स झेलने की होती है. इट्स नॉट इजी. There are so many comments. Lipsa says, जब मेरा होने चोरी हुआ था, they said they had much more important cases to solve. Exactly. That's exactly what they say. I agree. Chindrelekha says, there was an incident with my friend. She reported to the police that her travel bag is lost, and the police said he wished it had been lost with phone so that he could track the bag with the phone GPS. That's the most ludicrous way to get rid of the trivial complaints. Exactly, Taran, Chindrelekha. You're absolutely right. This is what even I as a lawyer had to face. Even I as a lawyer had to face these kinds of things. Okay. This is the hard reality of today. So closing the gaps in criminal justice. States could do better in incorporating the Supreme Court's crucial guidelines to overcome certain deficiencies. Now, these are very trivial things that we have discussed. When these trivial things can be so irritating and can be so painful for a common man like us, can you imagine that when the victim had to face these kinds of difficulties after being a victim of such a big crime like rape or murder? Can you imagine? That is why Supreme Court has issued certain guidelines to overcome certain deficiencies in various aspects. Okay, like we came across the case of Vishakha. Do you remember the Vishakha guidelines of 1997? Do you remember the Vishakha guidelines of 1997? Do you remember the Vishakha guidelines of 1997? Yes, sexual harassment at workplace. Yes, Bhavri Devi case. Lipsa Chaudhary, very good. That was the case in which the Supreme Court issued certain guidelines to the central governments and state governments to, incorporate those guidelines and transform them into a piece of law or a piece of legislation. You know, but the central government and the state governments, they were reluctant to do that. The Supreme Court's plea fell on deaf ears, and these governments did nothing until and unless a girl who was named Nirbhaya by the media and the society was brutally raped on 16th December 2012 on the streets of Delhi. When this brutal rape not only shook the conscience of the entire country, but it became an international news and point of discussion for the people across the globe. Only then the central government and the state governments, they constituted the JS Verma committee. They wanted this committee to come out with some legislations to prevent these kinds of crimes. And then Vishakha guidelines were taken into consideration by the government. Recently, we studied about Shakti Vahini versus Union of India. Do you remember Shakti Vahini versus Union of India? Shakti Vahini versus Union of India was a case in which the Supreme Court issued guidelines for the central government and the state governments to curb the menace of honor killing. That the honor killing is something which should be addressed through a separate piece of legislation. We should have a separate law describing the offense and holding the good quantum of punishment for it, isn't it? So the Supreme Court has time to time issued crucial guidelines to overcome certain deficiencies. Now Prablin says in cyber crimes it is rare to get relief. I was receiving obscene messages from few fake IDs for a week, and when I made a complaint they did nothing about that and advised me to not use social media. Exactly. They want us to, refrain from getting into such things. They don't want to do anything. And it's very easy for these authorities to trace the perpetrator, to trace the criminals through IP addresses. It's not difficult. Even people like us, we know that these crimes are committed from Jamtara. जामतारा में ये सारे होते हैं, वहां से ये क्राइम्स होते हैं. पुलिस उसके बाद भी कुछ नहीं करती. कितने बड़े बड़े गैंग्स हैं जामतारा में, है ना, बट पुलिस कुछ नहीं करती. So there are states could do better in incorporating the Supreme Court's crucial guidelines to overcome certain deficiencies. Now last year, the Supreme Court of India, while hearing a criminal appeal, took suo motu cognizance of certain deficiencies and inadequacies which occurred during the course of criminal trials. As a result, it issued the necessary directions in reference case to issue certain guidelines regarding inadequacies and deficiencies in criminal trials versus the state of Andhra Pradesh 2021. This is the referential case. These directions inter alia included presentations of site plan, inquest report and body sketches and a post-mortem report in a uniform manner, photographs and videographs of a post-mortem in certain cases, and separation of prosecution from the investigation. The high courts and the state governments were accordingly asked to notify the draft Rules of Criminal Practice 2021, which all the states and the high courts had agreed upon with minor variations, and make consequential amendments in their police and other manuals. The Guwahati High Court issued the essential notification and incorporated the necessary changes in January 2022. Okay. Now last year, there was a criminal appeal in the Supreme Court of India. While hearing a criminal appeal, the Supreme Court of India took suo motu cognizance. You must be knowing suo motu by itself. Okay. Took suo motu cognizance of certain deficiencies and inadequacies of which occurred during the course of criminal trials. As a result, it issued necessary directions in referential case. Now the name of the case is to issue certain guidelines regarding inadequacies and deficiencies in criminal trials versus the state of Andhra Pradesh 2021. Okay. Now these directions inter alia included presentations of site plan. That the directions were on which issue? That there should be presentation of a proper site plan, inquest report and body sketches in a post-mortem report in a uniform manner, photographs and videographs of a post-mortem in certain cases, and separation of prosecution from the investigation. Okay. No, Ankita, what is 141? These directions inter alia included presentation of site plan, inquest report and body sketches in a uniform manner, photographs and videographs of a post-mortem in certain cases, and separation of prosecution from the investigation. The high courts and the state governments were accordingly asked to notify the draft Rules of Criminal Practice 2021, which all the states and the high courts had agreed upon with minor variations, and make consequential amendments in their police and other manuals. The Guwahati High Court issued the essential notification and incorporated the necessary changes in January 2022. Okay. The high courts and the state governments, they were asked in these directions to notify that you have to draft Rules of Criminal Practice 2021. Okay. And all the states and all the high courts in India, they had agreed upon that we are going to draft these Rules of Criminal Practice 2021 with minor variations, because minor variations are allowed even in central legislations like CRPC. Okay. And make consequential amendments in their police and other manuals. You can, the circumstances differ from every state to state. So, in such manner, had agreed upon with minor variations and make consequential amendments in their police and other manuals. The Guwahati High Court issued the essential notification and incorporated the necessary changes in January 2022. In fact, the Guwahati High Court has already done it. Okay. The Guwahati High Court has already done it. Now, have you understood this paragraph? If you have any question, any confusion, you please ask me. Only then I'll move ahead. Any question? Understood. Okay, all of you have understood. Now, preparing a site sketch. How important it is to prepare a site sketch for the police authorities. The police reaches the crime spot. It prepares a site sketch. That site sketch is included in the charge sheet. Okay. That is included in the charge sheet, and that is very important for the court to ponder upon it, because it properly explains the entire entire event in a chronological sequence. This happened, that happened, the body of the deceased was lying here, blood stains were here, this was here, this was here. These kinds of things are properly in detail. It's a meticulous and picturesque description of the crime scene. So it's very important. The Criminal Procedure Code mandates that the officer in charge of a police station shall, on receiving information about the commission of a cognizance offense, proceed to the spot of the crime in person to investigate the facts and circumstances of the case. The general practice on reaching the spot is to prepare a site sketch that show details of the crime scene and collect evidence which could connect the presence of the criminal. Okay, I'm reading it again. The CRPC mandates that the officer in charge of a police station shall, on receiving information about the commission of a cognizable offense, this should be cognizable offense, proceed to the spot of the crime in person to investigate the facts and circumstances of the case. The general practice on reaching the spot is to prepare a site sketch that show details of the crime scene and collect evidence which could connect the presence of the criminal. The court has previously held that a site plan drawn on a scale is admissible if the witnesses corroborate these statements of the draftsman that they showed him the places. The contents of the site map would not become admissible as evidence merely by its exhibition by the investigating officer. Okay. What is the general practice? This is what has been mandated by the CRPC, that the officer in charge of the police station, once he receives the information about the happening of a cognizable offense, he should proceed to the spot personally and to investigate the facts and circumstances of the case. And the general practice is that when after reaching the spot, he has to prepare a site sketch that show details of the crime scene and collect evidence which could connect the presence of the criminal with the crime. The court has previously held that a site plan drawn on scale is admissible if the witnesses corroborate these statements of the draftsman that they showed him the places. The contents of the site map would not become admissible as evidence merely by its exhibition by the investigating officer. Okay. The court has previously held that a site plan drawn on scale is admissible if the witnesses corroborate these statements of the draftsman that they showed him the places. The contents of the site map would not become admissible as evidence merely by its exhibition by the investigating officer. The guidelines issued now say that the site sketch prepared by the investigating officer shall be followed by a scaled site plan prepared by a police draftsman if available on another authorized or nominated draftsman by the state government. Therefore, looking at the importance of a site plan which captures the details of a crime scene and its surroundings, particularly in a case of suspicious death, the police need to develop its own cadre of draftsmen. Okay. Now, the guidelines which have been issued by the Supreme Court in this referential case, in which the Supreme Court took a suo motu cognizance, it's versus the state of Andhra Pradesh 2021. These guidelines say that the site sketch prepared by the investigating officer, it shall be followed by a scaled site plan prepared by a police draftsman if available, okay, or another authorized nominated draftsman by the state government. Therefore, looking at the importance of a site plan which captures the details of a crime scene and its surroundings, particularly in case of a suspicious death, the police need to develop its own cadre of draftsmen. We should have professional draftsmen who can prepare the site sketch very neatly, very meticulously, because it's very important to collect the evidence and understand and connect everything with the criminal. Okay, so there should be a police draftsman or someone authorized or nominated by the state government who can do it in the best way. Okay, because the site plan in case of a suspicious death is very important, and therefore the police need to develop its own cadre of draftsmen. Okay, understood? Have you understood this point? The site plan. The guidelines mandate that every medico-legal certificate and post-mortem report shall contain a printed format of the human body with both a frontal and rear view on its reverse and injuries, if any, shall be indicated on such a sketch. Okay. The guidelines mandate that every medical legal certificate and post-mortem report shall contain a printed format of the human body with both a frontal and rear view on its reverse and injuries, if any, shall be indicated on such a sketch. And everything, medical legal, whatever the medical legal certificate says, whatever the post-mortem report says, okay, these certificates, these post-mortem reports, they shall have the printed format of the human body, both frontal and rear view, on its reverse and injuries, if any, and shall be indicated on such a sketch. Okay. This entire view, the frontal and the rear view, it shall be indicated on such a sketch. So for that we need professional draftsmen. Okay, we need professional draftsmen for that purpose. Understood? Have you understood this? Now tell me, how many of you have undergone internships at the National Human Rights Commission? During the internship at National Human Rights Commission, there are 2-3 sessions which are dedicated to the post-mortem, and those sessions are taken by the doctors from All India Institute of Medical Sciences, and they usually teach the interns how the post-mortem is conducted. They show real dead bodies. They show wounds, different kinds of wounds, different kinds of injuries, and how the post-mortem report is prepared. There is one front view, there is one rear view. Okay, and these details are to be shown in a side sketch. Okay, these things are to be shown in a side sketch. If any one of you has ever undergone internship at the National Human Rights Commission, you would probably be knowing this, that how those those things are conducted. Although it's not easy to witness it. Sometimes you feel nausea and it becomes unbearable sometimes to look at those things, but that's a part of our profession as a criminal lawyer. Okay, so have you understood up till here the importance of the side sketch? And that is why this side sketch, the proper drawing of the side sketch, was included in the guidelines of the Supreme Court. Now, testing veracity. Chitralekha says, I haven't, sir, but I'm doing MA in criminology and forensics. Wow, that's great. We have recently had our classes on crime scene recording and importance of medical legal. That's great. So it must be very easy for you to have a grip of everything which is there in today's PDF document and whatsoever we are discussing, isn't it? So these things are very important. Now, testing veracity. The purpose of preparing an inquest report is to ascertain whether a person has died under suspicious circumstances or died an unnatural death, and if so, what the nature of injuries are and the apparent cause of death. Okay. The purpose of preparing an inquest report, this is the most important line. What is an inquest report? Inquest report is to ascertain whether a person has died under suspicious circumstances or died an unnatural death, and if so, what are the nature of injuries and the apparent cause of death. That means Through inquest report, we come to know about the nature of injuries. We come to know about the cause of death. Unless and until we don't have an inquest report, it will be very difficult to ascertain, what if you have found somebody as a police officer or as a criminal lawyer, you have found somebody hanging with a fan. Perhaps he must not have died while hanging on the fan. There is a possibility that he was killed earlier and then his body was hanged with the fan. Okay. Now, in order to make a case of suicide, sometimes these tactics are followed by the criminals. So it's important to ascertain the cause of death, to come out with the nature of injuries, to decipher whether the deceased died under suspicious circumstances or died an unnatural death. Okay, so it's important to ascertain the cause of death, and for that, what is important? It is important to have an inquest report. However, if the evidence and materials collected during an inquest make it a prima facie case of any offense, a criminal case is registered and regular investigation taken up even without any formal complaint from anyone. Okay, Chitralekha says that one of our topics is how to differentiate between suicidal hanging and homicidal strangulation. Exactly. You must be reading about different marks on the throat, around the throat. There's one V mark, there's one U mark, there's one O. I mean, there are different kinds of marks. When a person is hanging with a fan that means there's going to be a different mark. There's a lot of difference between the marks of homicidal strangulation and marks through suicidal hanging. Yes, exactly. Based on marks on the neck and other post-mortem changes medico-legal are to ascertain. That's exactly. And that is what inquest report is all about. Okay, so however, if the evidence and materials collected during an inquest make it a prima facie case of any offense, a criminal case is registered and regular investigation taken up even without any formal complaint from anyone. It is settled law that the contents of the inquest report cannot be treated as evidence. Contents of the inquest report cannot be treated as evidence, but they can be looked into to test the veracity of the witnesses of the inquest. However, if the investigating officer himself observes and records evidence, it is treated as direct or primary evidence in the case and the best in the eyes of the law. Okay. It is settled law. What is the settled law? That the contents of the inquest report cannot be treated as evidence. You cannot treat the inquest report as evidence, but they can be looked into to test the veracity of the witnesses of the inquest. That means whatever, every evidence needs corroboration. No evidence except a few like dying declaration can become the sole ground for conviction of the accused. But the most of the evidences, they need corroboration. Inquest report is a kind of an evidence which also needs corroboration. So whatever the contents of the inquest report are, they need to be corroborated with the testimony of the witnesses. Okay, all the testimony of the witnesses need to be corroborated with the contents of the inquest report. Once this happens, it becomes easier for the court to believe that the witness has testified exactly the same what was contained in the inquest report. That means there is truth involved in the evidences. However, if the investigating officer himself observes and records evidence, it is treated as direct or primary evidence in the case and the best in the eyes of the law. And the best in the eyes of the law. Similarly, the post-mortem report is a document which by itself is not a piece of substantive evidence. It is the statement of the doctor in court which has the credibility of substantive evidence. The post-mortem report can only be used as an aid to refresh the memory of the doctor while giving evidence. The post-mortem report, what is the post-mortem report? It is a document which by itself is not a substantive piece of evidence. It is not a substantive piece of evidence. It is the statement of the doctor in court which has the credibility of substantive evidence. When the doctor comes to the court and he testifies, then the credibility of the post-mortem report as a substantive piece of evidence increases. The post-mortem report can only be used as an aid to refresh the memory of the doctor while giving evidence. As an aid to refresh the memory of the doctor while giving evidence. The significance of the evidence of the doctor lies vis-a-vis the injury appearing on the body of the deceased person and the likely use of a weapon. Okay. What is the significance of the evidence of the doctor? It lies, vis-a-vis, along with the injuries appearing on the body of the deceased person and the likely use of a weapon So these things are corroborated. Okay, now for better scrutiny, the National Human Rights Commission has already laid down similar guidelines for cases of deaths in police custody. The importance of body sketches in a uniform format in an inquest report and a post-mortem report can be overemphasized. The NHRC, it has already laid down similar guidelines for cases of deaths in police custody. The importance of body sketches in a uniform format in an inquest report and a post-mortem report can be overemphasized. Their standardization will not only help the court to better appreciate these reports and scrutinize the evidence, but will also help the investigating officers and doctors to refresh their memory with more clarity. Okay. What is the importance of body sketches in a uniform format in an inquest report? The contents of the inquest report, the contents of the post-mortem report cannot be overemphasized. Their standardization, they just help the court to better appreciate these reports and scrutinize the evidence. They are used to corroborate the other evidences. Okay. They also help in investigating officers and doctors to refresh the memory with more clarity, because doctors, they do a lot of postmortems, and the officers, the investigating officers also, they solve a lot of cases. So these reports are mostly used to refresh their memory with more clarity. Okay, that's it. Yes, Chitralekha, you are absolutely right that I explained this in Ascertain versus the state of Himachal Pradesh case, where the person was hit once with an axe, but he died. But she was actually the mother of the appellant in this case, right? Am I right? She died right there, but the statement was exaggerated. So the contents of the post-mortem report or the contents of the inquest report, they should not be overemphasized. Once you have submitted it, it's all right. Now these reports will be used for the purpose of corroboration of these contents, of their contents with the other evidences. Okay. The Supreme Court has directed that in case of death of a person in police action or death in police custody, the magistrate or the investigating officer shall inform the hospital to arrange for photography and videography for conducting post-mortem examination of the deceased. The Supreme Court has directed that in case of death of a person in police action or death in police custody, the magistrate or the investigating officer, in this is, we are talking about the guidelines in this present case. Okay. The state of Andhra Pradesh case of 2021. In this code, one of the directions issued by the Supreme Court is this, that in case of death of a person in police action, what if a person dies in police custody? Already there is a landmark judgment on this issue of DK Basu versus the state of West Bengal. Okay, and there are so many guidelines and so many instructions issued in DK Basu versus the state of West Bengal. But the Supreme Court in this case has also directed again that in case of death of a person in police action or death in police custody, the magistrate or the investigating officer shall inform the hospital to arrange for, what is the job of the investigating officer? He should immediately inform the hospital to arrange for photography and videography for conducting post-mortem examination of the deceased. That means post-mortem examination should be conducted in camera. उसकी पूरी वीडियोग्राफी होनी चाहिए, क्योंकि यूजुअली क्या होता है कि जब पुलिस कस्टडी में डेथ होती है, then the police officer, they try to influence the doctor to prepare a manipulated post-mortem report, so that those people who actually killed them after subjecting him to extreme third degree torture, they must not be implicated and they can escape and save their skin. Okay, so photography and videography of the post-mortem examination will prevent the doctors from making a manipulated report, and everything will be transparent. Okay, so for photography and videography for conducting post-mortem examination of the deceased, similar guidelines. Now this is one of the directions issued by the Supreme Court. Now similar guidelines, they were first issued by National Human Rights Commission back in 1995 and then revised from time to time, are being meticulously implemented by the enforcement agencies, and now the enforcement agencies are now meticulously implementing these guidelines, because these are the kinds of guidelines which were already issued by the National Human Rights Commission way back in 1995. Okay, then the Supreme Court in People's Union for Civil Liberties versus the state of Maharashtra 2014 issued similar guidelines for deaths in exchange of fire with the police. Okay, the Supreme Court in People's Union for Civil Liberties versus the state of Maharashtra in 2014 issued similar guidelines for deaths in exchange of fire with the police. Once there is an exchange of fire with the police is has opened an indiscriminate firing on the gangs of criminals. Then also that was the case of People's Union for Civil Liberties versus the state of Maharashtra 2014, in which the Supreme Court issued similar guidelines that in case where there is an exchange of fires between the police and the criminals, and in case any criminal dies, what and how the post-mortem has to be conducted. Okay, have you understood? Are you getting these points? Are you getting these points? Now the implementation of the scheme of having trained photographers at police stations. In accordance with Supreme Court's ruling of 2018 in Shafi Muhammad versus the state of Himachal Pradesh, the implementation of the scheme of having trained photographers at police stations, in accordance with Supreme Court's ruling of 2018 in Shafi Muhammad versus the state of Himachal Pradesh, is also underway in a phased manner, so that scenes of heinous offences are videographed and photographed using digital cameras as a desirable and acceptable practice, and their hash values taken to make the evidence tamper-proof. Okay, the implementation of this scheme of having trained photographers, that means you should have trained photographers at the police stations also, because the Supreme Court has already issued this ruling in 2018 in the case of Shafi Muhammad versus the state of Himachal Pradesh, in which the Supreme Court said that you should have trained photographers at the police station. At least that photographer should be authorized to click photos and take the snaps of anything, whatever the police is doing in the police station. And now the implementation of these guidelines, they are underway in a phased manner. Now the states are trying to implement them in a phased manner. so that the scenes of heinous offences are videographed and photographed using digital cameras as a desirable and acceptable practice, and their hash values taken to make the evidence tamper proof. You know, they should be tamper proof evidence. The videographs and the photographs would exactly tell us the bare reality, the naked reality of what is happening in the police station. And this was the ruling which was already issued by the Supreme Court in 2018 in Shafi Mohammed versus the state of Himachal Pradesh. Okay, then comes the draft code. Now provides that the investigating officer shall seize such photographs and videographs, preserve the original separate memory card, and obtain certificate under section 65B regarding admissibility of electronic records of the Indian Evidence Act 1872. Now, since everything has gone digital and is stored in an electronic form, so these photographs, they are now like you are going to receive them on your laptops, on your phones. So instead of preparing the hard copies of these photographs, it is important to save them in an electronic form, and video is going to be saved in an electronic form, and the investigating officer should save them in a separate memory card and obtain the authenticity of certificate of authenticity from the designated authority under section 65B of the Indian Evidence Act 1872, because section 65B is regarding the admissibility of the electronic records. If you're presenting an electronic record, there has to be a certificate which should be issued by the designated authority about the authenticity of the electronic evidence. Okay, you cannot produce any electronic evidence without a certificate. It becomes admissible only when the admissibility, it becomes admissible only when there is a certificate of its authenticity issued by the concerned authority. Understood? The purpose of these guidelines is to ensure that there is uniformity of procedure in dealing with cases of death in police action or police custody without any tampering of evidence. Therefore, it will be appropriate for the police forces across the states to speed up implementation of the above scheme and have their own cadre of photographers so that expertise is maintained at the police station level. Okay. The purpose of these guidelines, what is the purpose of these guidelines? It is to ensure that there is uniformity of procedure in dealing with cases of death in police action or police custody without any tampering of evidence. Okay. The purpose of these guidelines is to ensure that there is uniformity of procedure in dealing with cases of death in police action or police custody without any tampering of evidence. Therefore, it will be appropriate for the police forces across the states to speed up implementation of the above scheme and have their own cadre of photographers so that expertise is maintained at the police station level. Now, on investigation, the Supreme Court has further directed that the state government shall appoint advocates other than public prosecutors to advise the investigating officer during investigation. Currently, in many states, a public prosecutor advises the investigating officer to check and make up for any deficiency in investigation before submitting the charge sheet in the court. Okay, now there's one important thing which you should know. Who fights the case on behalf of the state? For example, a person has committed a crime, then who is going to fight the case against him? For example, Mr. X has committed a crime. The case will be instituted in the name of the state, not in the name of the victim. It will be the state versus Mr. X, isn't it? And who is going to appear on behalf of the state from the prosecution side? It will be the public prosecutor. He will be the public prosecutor duly appointed by the state government. He will be the public prosecutor duly appointed by the state government. Okay. Now, currently, what is the situation? The situation is that the investigation, when the investigation is carried out by the investigating officer, and when the investigating officer collects the evidence, investigates the matter and files the charge sheet, at every level, who assists the investigating officer and who advises him to prepare the charge sheet in the best possible manner? It is the public prosecutor. Okay, it is the public prosecutor who does this. But currently in many states, a public prosecutor advises the investigating officer to check and make up for any deficiency in investigation before submitting the charge sheet in the court. Okay. Currently, in many states, a public prosecutor advises the investigating officer to check and make up for any deficiency in investigation before submitting the charge sheet in the court. Okay, in the court. So there, the public prosecutor first advises the investigating officer to prepare the charge sheet. Okay. And then the same public prosecutor happens to stand in the court, to fight the case against the accused. Previously, there have been conflicting judgments by the Supreme Court on this issue. The issue is that the advocates for advising the investigating officer should be separate, and the public prosecutor who fights the case in the court should be the separate one. Okay, there should be separation of investigation and trial procedures. The same person is assisting the investigating officer in filing the charge sheet, and the same person is then coming to the court and fighting the case. There should be separation of investigation from the trial. Okay. So previously there have been conflicting judgments by the Supreme Court on this issue. The court in R. Sarla versus T.S. Velu 2000 held that as per the scheme of the CRPC, the investigation ends with the formation of an opinion by the police as to whether on the material collected a case is made out to place the accused for trial. The formation of the said opinion by the police is the final step of the investigation. What matters at the investigation level is the final opinion formed by the police, and that opinion should not be manipulated and should not be influenced by any advice of the public prosecutor who is going to fight the case and who is going to take the advantages in the investigation in the trial. So the public prosecutor is an officer of the court, and his role essentially is inside the court, not outside the court. Okay, so the Supreme Court issued the guidelines in these cases saying that there should be separation of investigation from the trial level. Okay, more recently, in the state of Gujarat versus Kishanbai 2014, the court, while taking note of the many lapses in investigation, directed that on completion of the investigation in a criminal case, the prosecuting agency should apply its independent mind and require all shortcomings to be rectified if necessary by requiring further investigation. More recently, in state of Gujarat versus Kishanbai 2014, the court, while taking note of the many lapses in investigation, directed that on completion of the investigation in a criminal case, the prosecuting agency should apply its independent mind. That means the investigating officer should apply its independent mind and require all shortcomings to be rectified. If necessary by requiring further investigation. Okay, public prosecutor should not influence the opinion of the investigating officer. Since investigation, Chitralekha says public prosecutor are another wing that needs major reforms. Exactly, completely agree with you. Now, since investigation and prosecution are two different facets in the administration of criminal justice, the 3-judge bench of the Supreme Court has now rightly asked the states to separate the two wings. Chhattisgarh has sanctioned a cadre of law officers who shall function independently of the public prosecutors and will have no role in the court to assist the investigating officers in educating and improving investigation work. Other states should also follow suit. Similarly, while the creation of a cadre of draftsmen and photographers may take time, Executive orders may be issued without further delay, following by training of investigating officers and medical doctors in order to implement the Supreme Court's directives. Okay. Chhattisgarh has already done that. It has appointed cadre of law officers who shall function independently of the public prosecutors, and they will have no role in the courts. They will simply assist the investigating officers in educating and improving the investigation work. That's it. Okay. And the role of the public prosecutor is inside the court, because he is an officer of the court. His role is inside the court. So he is going to stay inside the court. He is not going to participate in the investigation anyhow. He has to be kept out of it. Okay. So this was all about the closing the gaps in the criminal justice system. If you have any question, anything to add or supplement, please, you're most welcome to do that. Chitralega says some public prosecutors are corrupt enough to take money and not file counters and bail. I have known PPs who let go NDPS accused taking bribes. Their inefficiency just make defense counsel's job easy. It's very easy to be a defense counsel in India, especially in the state of UP and Bihar, because public prosecutors, they hardly do anything. In my criminal practice, I have seen public prosecutors coming to the court empty-handed completely and standing absolutely mum on the issue. I have seen defense counsels arguing vociferously to prevent the accused, and public prosecutor was standing simply like this, not saying anything. When the court asked him, do you want to say anything? He said that evidences are there, but defense counsel will not agree to it. He can be prosecuted under the evidences. That's all he said. That's all he said. Can you imagine? Because they have a fixed salary. They have already been appointed by the state governments. They have been given a government quarter to live in. Okay. They have a car. They have an accommodation, they have a salary, they have a government job, they have a job security, so they hardly care. I don't know if all the public prosecutors are like this, and I'm pretty sure that all the public prosecutors are not like this. There are some rotten eggs in the system. Some may be very honest, but some of them are literally unbearable. Okay. Naman is asking that he has not understood the 2014 case given in the last. Okay, one was the case of Sarala versus TS Velu, in which the Supreme Court, from the year 2000, in which the Supreme Court said that in the scheme of this CRPC, what is important? In the end of the investigation ends with the opinion of the investigating officer. Okay, and it is his opinion that matters the most, because he then files the charge sheet, he then frames the sections and he writes them in the charge sheet. It is his opinion. What if his opinion is manipulated by the public prosecutor? Then the investigation will not end solely by the opinion of the investigating officer. Public prosecutor's opinion will also be included in it. So that's what was said in 2000 judgment of the Supreme Court, that At the end of the investigation, the opinion of the investigating officer is important, and charge sheet should be filed in accordance with the opinion of the investigating officer, which should not be manipulated at all. Understood, Naman? And then in the 2014 judgment, State of Gujarat versus Kishan Bai, the Supreme Court said that there are so many lapses in investigation, and the prosecuting agency should apply its own independent mind rather than taking the advices from the public prosecutor. The investigating officer should and the investigating agency should apply their own independent mind. What have been they trained for? They are trained, they are educated, they know the law. Then why should they seek advices from the public prosecutor? They should apply their own mind. The job of the public prosecutor is inside the court. They're not supposed to assist the investigation officers in the investigation. Okay, that was what was said in the two judgments by the Supreme Court. Now have you understood, Naman? Have you understood, Naman? Okay. Okay, then I'm ending the live stream and signing off. And let's meet tomorrow with another topic. Till then, bye bye. Thank you.